I'm Robert Upakes. This is a revision lecture on equity and trusts, and the first lecture is an overview of the subject. I'm going to concentrate on trusts because they show light on the way that equity operates, and so in a sense what I'm going to do is look at the operation of equity through the lens of trusts. But first of all, I need to look at the historical development of equity very quickly, just to set it in context. Historically, equity developed to remedy the deficiencies of the common law. It originated a long, long time ago, at the time roughly of the Crusades, in other words, a very long time ago, when people would go off to fight a crusade, and the person going off to fight would entrust his property to someone else to look after for his wife and children. So far as the common law was concerned, the property belonged to the person to whom he'd entrusted it, and that meant that the wife and the children's interests would be denied. That was clearly unjust, and so they developed a system of, if you like, justice, equity, which remedied that, and they developed a series of rules which said that in a circumstance like that which I've outlined, the person to whom the property was given or entrusted should look after it for the interests or respecting the interests of the wife and the children. And so equity says that the property which belongs to or is given to someone else must be held for the benefit of those third parties, the wife and children in the example I've just given, and that the person to whom the property is entrusted can't keep it for themselves. As I say, the common law does not acknowledge the rights of the wife and children, who are called third parties. It merely says that the person who owns the property is the absolute owner of it, and it ignores the rights of those other people, which of course, as a matter of justice, should be respected. So over a period of time, over a period of centuries, they developed this system of equitable rules, which were developed by a man called the Chancellor. The Chancellor was the historical predecessor of what we now know as the Prime Minister, and the King, or the Sovereign, devolved to the Chancellor the dealing with or handling of these kinds of disputes. And so the Chancellor developed a set of rules which gradually became formalized over a period of centuries, and that essentially is the foundation of the system of equity as we know it. And historically, the Chancellor was not in fact a lawyer, but a cleric, but subsequently he became a lawyer, and he sat in his own court, called the Court of Chancery, Chancery being linked with the word Chancellor, and that now is to be seen in the Chancery Division of the High Court of Justice, where trusts are still dealt with. So, as I say, the point about it all was that the common law ownership, which does not acknowledge third-party rights, was modified by the Chancellor to impose rights or impose obligations, I should say, on the owner of property and oblige that owner of property to respect the third-party rights, for otherwise it would be inequitable, and that's what equity is all about. So if we look at the nature of equitable rights, firstly, they must be contrasted with legal rights. A legal right is a right which is good against everyone. If I own property absolutely, I have absolute rights against everyone, and those are the best possible rights. The property, therefore, cannot be taken away from me. On the other hand, an equitable right, the right of the wife and the children, the example I gave a moment ago, an equitable right is good against everyone except the bona fide purchaser of the legal estate for value without notice. Now, in terms of land law, which is not relevant to this particular set of lectures, but we just need to be aware of it, in terms of land law, the bona fide purchaser rule has been effectively subsumed into the rules of land registration. But the importance of the bona fide purchaser rule is that if you have property held on trust by someone, which is given to someone else, the bona fide purchaser rule does not apply, because the person to whom the property is given is not a purchaser. So if trust property is given by a trustee to someone else, their bona fides is irrelevant, or their good faith is irrelevant. The fact of the matter is that they're not a purchaser, and therefore they can never take free of equitable rights and the rights given by a trust. So one can contrast legal rights with equitable rights, and in the context of trusts, that's an important point to be aware of. The other point is the distinction between legal remedies and equitable remedies. Again, these have developed over a long period of time, so what I'm saying is a summary of a long period of history. But an example of a legal remedy is damages. If you injure someone, damages are payable to the victim. It may well be that they shouldn't have been there, or they should have looked what they were doing, in which case, as a matter of the law of negligence, the damages will be reduced by the rules of contributory negligence. In the case of an equitable remedy, the equitable remedy does not follow automatically. Examples of equitable remedies are the injunction and an order of specific performance, sometimes called SP for short. An injunction is usually an order not to do something, sometimes an order to do something, and an order of SP, or specific performance, is an order to perform a contract, usually a contract for the sale of land. Now, the nature of those equitable remedies is that they are discretionary. They are at the discretion of the court and do not follow automatically. A common law remedy follows automatically from the determination that there's been a breach of contract or tort. An equitable remedy is discretionary, and you cannot say you are automatically entitled to it. It is at the discretion of the court, and the court will grant that remedy according to settled principles, but nevertheless the court is not obliged to grant it if it doesn't think it appropriate. And there's a whole series of principles which one could go into about the principles upon which, or the basis upon which, equitable remedies are granted, but that is the basis, that is the basic principle behind it, that it is a discretionary remedy and not an automatic remedy. And so, for example, if the person seeking the remedy themselves is to blame in some way, then they will not get the remedy. And there's a principle which says that he who comes to equity must come with clean hands, and that means that if the person seeking the remedy is not beyond reproach, they won't get the remedy. The next matter I want to talk about is trust and third-party rights. If I decide to set up a trust for, let us say, a group of students, then what I'm going to do is I'm going to transfer a block of property or shares to people who are called trustees to hold on behalf of that group of students who are called beneficiaries. I'll explain a bit more about that in due course, but that's the broad purpose of a trust, or the broad ambit of a trust. So we have three parties. We have me, who am setting up the trust. We have the people to whom I've transferred the property or the money, who, as I've said, are called the trustees. And we have the beneficiaries, which in my example is the group of students. But it should be noted that there is no relationship between me and the students. I've decided to benefit the students, but I don't have any obligation to do so. I've merely done so because I want to. I've transferred, or I'm about to transfer, the property to the trustees, and when they have the property and the trusts have been declared, then they hold that property on trust for the beneficiaries, the students, and if they deviate from the terms of the trust in any way at all, they're in breach of trust. So there is an obligation on the part of the trustees, once the trust is set up, or as we sometimes say, completely constituted, once the trust is set up, the trustees have an obligation to hold that property on trust for the beneficiaries. As I say, the important point to note is that so far as I and the students are concerned, we have no relationship at all, and there is no obligation upon me to do this. So if we then look very briefly, and of course this is in the context of an introductory lecture, if we look very briefly at the nature of a trust, we have effectively three parties. We have the person, the trustee, who owns the property, but instead of that person owning the property absolutely, they own the property subject to an obligation to manage it for the benefit of other people, third parties, whom I've called the beneficiaries. And that is this basic structure of a trust. There are slight exceptions to that which I'll look at in due course, but that is the main structure of a trust. And if we just look very briefly at the word beneficiary, the point about it is that the word beneficiary means someone who gets a benefit. So if we go back to the example of the trustee holding the property, the trustee holds the ownership of the property or owns the property, but gets no benefit from it. The benefit, whatever the benefit is, passes to the beneficiary. So if we take an example of a shareholding, for example, the trustee owns the shares. The shares are in a company which, if it's doing reasonably well, will declare dividends, and those dividends are not payable to the trustees, they're payable to the beneficiaries, who thus get an income from the shareholding. So one may say, well, and this is my next point, what is the reason for a trust? Why do we need to have trusts? Well, we can divide the reasons into two groups, effectively. There are domestic reasons and there are commercial reasons. In the context of a domestic trust, or trust for a domestic reason, there are all sorts of reasons why one would want to have a trust. Historically, they're probably more important than they are now. But for example, if one wants to create a succession of interests, then one would have to create a trust. The classic example to give on that is to A for life, remainder to B for life, remainder to C in fee simple. In other words, if you deconstruct that, A has a life interest. When A dies, B gets a life interest, which he or she enjoys for the rest of their life. And when B dies, C gets the fee simple in possession, or the property in possession, and the trust ends, and they take absolutely. But the interests of A and B need to take place behind the guise of a trust because of the operation of Section 1 of the Law of Property Act 1925, which says that when you have a succession of interests of the sort I've outlined, you must create that succession of interests behind a trust. So, as I say, if we go back to the example, A for life, remainder to B for life, remainder to C in fee simple, A and B will have to take life interests behind a trust. In other words, there will be trustees who will hold the property on trust for them successively. But when B dies and C takes over, then assuming that C is over the age of 18, over the age of majority, in other words, C will take absolutely and the trust will come to an end. And at that point, C, assuming he or she is of the age of majority, will be able to call upon the trustees to vest the property, to transfer the property to them. That's one example. Another example of domestic trust would be where one buys property jointly with someone else. Again, the operation of the Law of Property Act means that there needs to be a trust. So if someone buys property with someone else, doesn't matter what the relationship is between them, it could be two friends, it could be two lovers, it could be a husband and wife, it really doesn't matter. But if you buy property jointly with someone else, a trust is bound to come into existence. Now, I shall return to looking at those kinds of trusts, joint ownership trusts, a bit later when I look at common intention constructive trusts, but that is broadly speaking what it is about. There are other reasons for domestic trusts, but those are the two main ones, and those will serve for the moment. So far as commercial trusts are concerned, possibly the most important reason for having a trust is the existence of pension schemes. All pension schemes take place behind a trust. And so during my working life, if I'm a member of a contributory pension scheme, every time I get paid a chunk of my salary, a bit of the salary will be siphoned off by my employer and paid to the pension fund. And the pension fund consists of trustees who hold the property on the trust of the pension fund. And one of the terms of the trust is that when I retire at the age of 65, or whenever, the benefits of the fund, or benefits of the fund which are attributable to me, are payable to me. So I pay in during my working life, and when I satisfy the terms of the trust, when I retire or turn 65, then I become a beneficiary under the trust, and the pension fund is held on trust for me. So if you think about that, if you think about the importance of pension funds and the value of money and property in pension funds, their commercial importance is absolutely huge. And to understand pension law at all, one will need to understand the law of trusts. Now, the other thing I want to say a little bit about in this introductory lecture is the classification of trusts. The examples I've given you so far are examples of what are called private trusts. And basically, trusts divide into two groups. There are private trusts, which I've given examples of already, my trust for the benefit of the students, or trust for successors, A for life remainder to B for life. Those are all private trusts. They are to be contrasted with what are called either public trusts or charitable trusts. The two terms are interchangeable. So you've got on the one side you've got private trusts, and on the other side you've got public trusts or charitable trusts. Now, the first part of these lectures is going to be devoted to private trusts, and then later on I shall talk a bit for a lecture or two about public or charitable trusts. Essentially, the distinction between the two is that a private trust is a trust for a group of private individuals. That group may be numerous or non-numerous, but nevertheless it is a group of private individuals. So a trust for my family is clearly private. A trust for a group of students at a university would be private. And a trust for employees of a large public company like British Telecom, for example, that would nevertheless remain private, despite the fact that Telecom is a huge employer. Nevertheless, a trust for the employees of British Telecom would remain a private trust. A public trust, on the other hand, is effectively, or in effect, a trust for purposes which are regarded by the law as charitable and which will benefit individuals. So, for example, a trust into cancer research would be a public or charitable trust. The purposes are research into medical matters. They will have a benefit on those who suffer from that particular condition, but it will benefit the public at large. It is for a public purpose, because the elimination of cancer from the population would, if it were achieved, be desirable. Though I dare say it's unlikely it will be, but anyway. The point about it is that it will benefit the public at large, anyone amongst the public who happens to suffer from that condition. Anyway, turning back to private trusts, which, as I said, is the subject matter of the first few lectures, private trusts effectively divide into two groups. On the one side, you get express trusts, and on the other side, you get what I would call non-express trusts. So firstly, let me look at express trusts. An express trust, as its name implies, is a situation where you set up a trust expressly. So in my example of a trust for the benefit of some students, I have set up a trust expressly, and I've said that the property is to be held by the trustees on trust for that particular group, however defined. So the point to note, let us just flesh that example out slightly. Let us say that I set up a trust for the benefit of law students at the University of Poppleton. Now, there are 2 points to note about that. Firstly, that the beneficiaries are law students, and secondly, that those law students must be at a particular university, which I call the University of Poppleton. If the trustees were to pay the money over, the income arising from the shares, if they were to pay it over to management students at the University of Poppleton, clearly they'd be in breach of trust. Equally, if they were to pay it to law students at the University of London, they would equally be in breach of trust. So they have to observe the express terms of the trust, and if they deviate from that, they've committed a breach of trust. Express trusts, in fact, then divide into two groups. Further, they divide into what are called fixed interest trusts and discretionary trusts. A fixed interest trust arises where the beneficiaries all have fixed interests. So an example would be, I give the property to my trustees to hold on trust for my grandchildren in equal shares. Each grandchild has an interest, and that interest is fixed by the number of grandchildren. So if there are 10 grandchildren, each one gets 10%. So a fixed interest trust is a trust where the interests of the beneficiaries are fixed by the instrument creating the trust. A discretionary trust, on the other hand, is a trust where the trustees have a discretion as to who they pay the income to. So if we go back to my law students at the University of Poppleton, the discretion would read something like this. my trustees may pay out the income arising from the trust to law students at the University of Poppleton in such amounts at such times and on such conditions, if any, as they think fit. And so that means that no one law student can say, I'm entitled to anything. It means the trustees have a discretion to pay out as they see fit to whomsoever they think needs it. So from year to year, the needs of law students might vary, and some might be in greater need than others from year to year. The trustees are not obliged to pay to any one person. They have a discretion. They have a choice, in other words. If we turn to non-express trusts, again, they effectively divide into two. They divide into what are called resulting trusts and what are called constructive trusts. In both cases, they arise in circumstances, and I'm going to look at them in more detail later, in fact. They arise in circumstances where, for various reasons, although the person involved or the people involved didn't think a trust would arise, because of the operation of various rules, a trust does arise. So what we find is someone holding property, and by reason of the operation of the rules of resulting or constructive trust, they have to hold that property on trust. No trust was intended. It may well be they didn't want a trust at all had they thought about it, but for various reasons, they are obliged to hold the property on trust, even if they didn't contemplate that that was going to happen. So, as I say, I shall look at those two in more detail later and give you some examples, but that I think suffices by way of introduction. There are one or two other points I just want to make before I finish this particular lecture. Firstly, it's important to bear in mind that trusts can be created either by someone who's alive, and those are called inter vivos trusts. So the example I gave you earlier of me setting up a trust for the benefit of law students, that would be what's called an inter vivos trust. It literally means between living people. The alternative is to set up a trust which comes into effect when one dies, and that is called a testamentary trust, because it's linked with one's will or one's testament, which is the instrument by which you direct where property is to go when you die. And the other thing I want to end this lecture with, or the final thing I want to end this lecture with, is terminology. If you cast your mind back to the example I gave you earlier of setting up a trust, I want to set up a trust, I transfer the property to my trustee and there to hold it on trust for the law students. Now I am called, since I'm doing this when I'm still alive, I'm called the settler. If I were doing it to come into effect on my death, I'd be called the testator. Or if I assume, in fact, I'd be called a testatrix. And so the settler or testator transfers ownership of the property to the trustee, that's the second party, and the trustee, or trustees more commonly, are obliged to hold the property on trust for the beneficiaries. And as I've already said, the word beneficiary is linked with the word benefit. The trustee has the obligation of holding the property. The beneficiary is the person who obtains the benefit. That concludes what I want to say in this first lecture, and I shall then go on to define a trust in the next lecture.